Hello everybody. In today's video, I'm very excited because we're going to be talking all about the EB2 National Interest Waiver. There is a tremendous amount of interest on the EB2 National Interest Waiver, also known as the NIW, for good reason. It can be a fantastic option for certain people that qualify. We're going to talk about a lot of these details about the EB2 NIW in this video, and I'm very pleased to be joined by a fantastic attorney, Giovanna Cain, who is extremely well versed in this particular immigration category. So we have the benefit of getting a lot of great insights from Giovanna. So welcome, Giovanna.
Thank you, Michael.
All right, so why don't we get started? And if you could just please provide a general idea about what is the EB2 NIW all about?
Absolutely. It is a pleasure to be here speaking with you today. And the EB2 NIW is basically a second preference employment-based immigration visa. And what does that mean? That this visa gives a pathway to the green card for employees, for foreign nationals that want to come work in the United States, but it does not require a sponsor. So this is a self-petition possibility for foreign nationals.
Yeah, exactly. So normally the standard EB2 immigrant classification would require an employee, like the person, the beneficiary, the person that's obtaining the immigration benefits, it would require something called a labor certification, where the employer would have to go through all these steps with the Department of Labor to show what kind of job that they have available and to do recruitment, to show that they tried to hire a U.S. worker and show that no U.S. worker that was suitable for the job was available. And they have to go through this very long process through the Department of Labor. The benefit of the National Interest Waiver is that essentially waives the requirement for that labor certification process through the Department of Labor, so somebody can get a green card much faster than the standard EB2. We're going to go all through the requirements of what it means to qualify for an EB2 National Interest Waiver, and we'll dive into these details. But as a general overview, the National Interest Waiver is this method of obtaining lawful permanent residence to the United States where the individual can get the green card on their own without the need for employer sponsor. As Giovanna mentioned, it's a green card option for people essentially through self-petition. They do not need an employer to sponsor them for this petition. You on your own could file this petition without needing an employer sponsor. And again, as I mentioned, you can forego the labor certification process. And as a result, in many cases, you can get your green card much faster than through the standard EB2 method. I kind of touched upon it, but what would you say some of the benefits are in getting a green card through the NIW process?
The main benefit is the self-petitioning aspect, because I say that that's the biggest challenge for a lot of very qualified professionals abroad that cannot find an American company to sponsor them, or they even have a company willing to hire them but not willing to go through a PARM process. Unfortunately, the backlogs on the Department of Labor side before you can even get to immigration has been discouraging a lot of employers to go through a PARM, even if they have the person, the talent that they want to bring here. So I see a lot of professionals on an L visa, O visa, or a different non-immigrant visa that can self-petition and then access the permanent residency and work for whichever company they want. So that's the benefit number two. After they access their green card, they are not limited or they are not tied to one company. They can decide the plan for their professional career, how they want to follow next. We do recommend that they keep faithful to what they presented to immigration. If they said that they're going to be a professional in engineering, that they don't just change completely their endeavor in their professional field, that they keep in the same arena so we don't incur any misrepresentation later on because they're becoming permanent residents later on. After 5 years of a successful permanent residency, they are eligible to become citizens as well. The other benefit that I see, like you mentioned, Michael, is the expedited part of this process. The labor certification can take up to 16 months, even longer sometimes. So bypassing that whole process and going straight into an I-140 application, usually, and we can go into more details later during this conversation, it goes about 2 to 3 months to gather all the documentation and build a solid package application to be submitted. And after you submit it, it's an average of 1 year, with premium processing less than that, to get a case approved. And with that approval, we have some other factors to analyze, but it's definitely bypassing in at least a year and a half, maybe 2 years of what a regular EB2 or EB3 case would take in time. And then finally, you can bring your spouse and children under 21 years old as beneficiaries as long as you as the professional are eligible. enroll. So that is a great benefit that if your children are under 21, instead of trying to get one visa per family member, you can bring all your family under your petition.
Those are fantastic benefits indeed. Getting a green card, again, as we both mentioned, without having to go through the Department of Labor. I've actually seen these labor certification process from the filing of the prevailing wage request, which is where the employer shows what type of job they have available, and then going through the recruitment and then filing the perm application. I would say that that process is going to take around 2 years in some cases to accomplish. So to be able to forego that entire process is a huge win. And as you mentioned, being able to get a green card for yourself, for your spouse, and for your children that are under 21 years old, fantastic benefits indeed. So take us through the process. What does this application process look like?
Absolutely. So the EB2 NIW has two different phases. The first phase is the EB2 itself, where I need to establish that the foreign national is eligible, and we have two pathways to determine that eligibility: advanced degree or exceptional abilities. The pathway of advanced degree, I need at least a bachelor's or a degree that is equivalent to a bachelor's in the United States, plus 5 years of full-time experience post-bachelor's completion. So if you have work experience from before or during that bachelor's, it is not going to count. And that needs to be full-time. It can be a part-time internship, and I can also have advanced degree through a master's or a PhD. If it's a master's or a PhD, I do not need to look into any years of experience. That alone will establish the pathway for advanced degree eligibility. The other way that we can establish this eligibility is through exceptional abilities, where I have 6 criteria and I need at least 3 of the 6 to be met. Among the 6 criteria, I have a degree, and it does not need to be a university degree. It can be learning institution, some other technical degree, but in the same field of the endeavor of the undertaking. I need at least 10 years of full-time experience. That can be before or after the completion of this degree. I need a professional association that this candidate is a member of. I need a license to practice that profession. And here I can use comparative evidence. For example, if you have a license in some sort of IT or CPA, to prove that you need a license to work in your field. I need a high salary. I need to demonstrate that this candidate has a higher salary than the average worker in that same field, in the same role. And finally, I need to show recognition. And recognition is any sort of achievements among your peers, supervisors, employers in your industry. We can use several evidence to demonstrate this recognition criteria. And if I can meet 3 of the 6, we can also defend through exceptional abilities. Here, going a little bit out of the basic lawful requirements of the statute, the officer has much more discretion in weighting the totality of the evidence to say yes or no for exceptional abilities. So we do tend to defend candidates through advanced degree whenever available. Even though if I do have someone that has both, I will use some of this exceptional ability evidence and criteria to defend the national interest waiver itself. And this is phase 2 that we are entering. The national interest waiver is the second part that makes this differential of the regular EB2. It's based on case of Danasar, the legal precedent from 2016 that opened the pathway for us to do this petition. So going into phase 2, we have the subjective part of the national interest waiver, where I have 3 prongs that need to be met. And the first prong is substantial merit and national importance. What does this mean? It's basically that the endeavor or undertaking needs to extrapolate the benefit of one employer and its immediate clients, or one doctor and its patient. I need to demonstrate that I'll burst this bubble and have an actual impact in society, in healthcare, in economy, infrastructure, in the different areas. And how do we do that? It's basically through an attorney arguing your case based in all the corroborating and all the supporting evidence that we can present. We need to demonstrate that this is something that will actually be meaningful to the United States, and that has an importance, not necessarily geographical, that will reach all the states of the United States, but that it will affect the industry, your peers, your colleagues, and society as a general. The second prong is the well-positioning to advance the endeavor. What does this mean? I will look into the trajectory of that applicant up until this point and how well-positioned that person is to advance what they are promising they will do to the United States. So you'll look at potential customers, potential investors, potential interest from governmental agencies, from grants, from different funding agencies. I can look at different employers that are ready to try to recruit this person. I can look into the recommendation and the impact impacting the industry in United States. So if I have a lot of employers trying to recruit this person in Australia, in Canada, that will not be relevant here. I need to demonstrate that that person is well positioned to advance their endeavor in United States. So we will rely on all their career up until this point, and that's why those points from exceptional abilities can be transported into helping us build a robust defense for a national interest waiver part as well. I can look into a license. I can look into a membership in a professional association. I can look into a high salary. All those criteria of extraordinary abilities also means that this is a professional that can advance the endeavor, that can fulfill the promise that they are bringing to the United States. And the third and final prong is that there will be a waiver of a job offer and therefore of a labor certification in light of us meeting prongs 1 and 2. I have done hundreds of cases and I have never seen one denial based solely on prong 3. What does that mean? If prongs 1 and 2 are met, prong 3 will probably be met as well. It is a conclusion, a consequence of us proving very well, establishing that your proposal has substantial merit, has national importance, and that you, the promising out this, the applicant, is well positioned to advance on that. And the consequence is that you will not need to go through a labor certification. You're not bypassing the normal process. You're actually someone that the United States need to be here, impacting your field, advancing your work, your endeavor. So they will give you that waiver and allow you to start working immediately.
Thank you so much for sharing. Just quickly recap. There's two parts to this national interest waiver assessment. There's part 1 where you're looking at, do they have an advanced degree or a bachelor's degree with 5 years of experience post receipt of the bachelor's degree, or are they a person exceptional ability? And you very clearly identified those 6 prongs of which the individual needs to meet 3 of them. And then once that assessment is made, you shift into this national interest waiver assessment where there's those 3 prongs based on DANASAR. And you have substantial merit and national importance, that the individual is well positioned, and that on balance, it's in the national interest to waive this component of having a job offer and a labor certification completed. So thank you so much for laying that out. Exactly what you mentioned regarding going back to substantial merit and national importance. If possible, can you kind of take out the legalese from it and just explain it to the layman's terms as best as you can? Because somebody could read substantial merit and national importance and they might think that you need to be the one that's developing the next cure for cancer or something like that. But you made it very clear earlier. You said it doesn't need to geographically target the entire nation. So can you kind of bring that prong, that specific substantial merit and national importance into more layman's terms to the extent that you can?
Absolutely. At the end of the day, I have several applicants concerned before and after filing asking me, do I need a Nobel Prize? What do I need? What does this officer want to see? And my answer will always calm them down, because no, at the end of the day, the statute does not say these are the threshold of what you need to demonstrate to have national importance, such as for EB1A, I needed a specific award or prize of international recognition. No, national importance, I just need to demonstrate that my proposal will benefit more than me and my clients. It's not one company having customers that will buy and generate profit, and that is the end. I need to demonstrate a positive impact that will have a chain impact in the industry. So I'll give you an example of an IT consultant. I defended the case, a software developer had very specific knowledge. He helped implement in the nation of Brazil the method of payment that the central bank started utilizing to have online payment over all banking, over all the infrastructure. It was something very revolutionary as a nation, and other countries are starting to implement it. So we were able to use that specific leading role that he had to build a consultancy in IT within his field in United States, and show that not only his customers directly would be able to benefit, but the nation where he was going to be establishing this proposal, because he has knowledge of how to implement something in such a level that he can teach his peers, he can mentor, he can impact how others in his same field are doing that, the software, the developing, the programming, and that does cause this chain effect.
That's national importance. What about substantial merit? That's great news for everybody that's considering a national interest waiver in terms of how you can argue that point of national importance. Now, if you can provide that same clarity on substantial merit, that would be wonderful.
Absolutely. Substantial merit, at the end of the day, I just need to make clear that threshold here, I believe, is even easier. It's just something something that is actually relevant to the United States. I'm not just going to sell popcorn in a corner, and I have nothing against popcorn. I love it. But what I'm going to do is actually meaningful in some way to the industry. So it's very easy for us to rely on the White House directives in saying we need more professionals. Like recently, there was a new development where I opened the definition of Schedule A workers for science, business, for more professionals, or I have all these directives about STEM and machine learning and AI to bring these workers here under different labor certifications. But I can rely on this type of governmental directives and mandates to say, hey, this is of course of substantial merit. I have governmental agencies. I have the White House itself saying we need more funds, we need more professionals. This is why we're investing and growing this area. This is impactful to us. So we'll use that to back our argument to the officer that this area is of course of substantial merit to the United States. And then we'll break into why this candidate himself or herself has the national importance level as well.
I encourage everybody to continue to stick around for this video because we're going to go through some industries could potentially qualify for a national interest waiver, and some of them might not be as intuitive as you would think. So stay tuned. So now, Giovanna, we now know the requirements. What about the filing process? How does it work in terms of the forms that get filed and so on?
Of course. So the main form is the I-140. It's the petition for an alien worker. Working on filing this form, we were going to need several evidence to back up our arguments. This is not a light process or just a few pages packed, just hundreds of pages. So I do need the cooperation of my client, of my applicant with me. We're going to need records of the diploma, transcripts, and have it all, the equivalency done, and have translation of foreign documents. We need letters of recommendation. We need letters verifying the employment on all the former employers that this applicant had. We're going to rely on any news articles, patent awards received, pictures in lectures, publications, and number of citations that these publications have reached. So here I'm just mentioning from the top of my head, once we are actually analyzing each specific case, I'm not going to require publication out of someone that worked as an engineer in the technical field out there in the oil and gas industry, and they were not actually just sitting down somewhere in academically and doing research, but they will still be able to meet the threshold of proving all the prongs just with different level of evidence. So there is no one magical formula for every applicant. We just look in very specific background and circumstances to then build the evidence that makes sense to be presented in that case. But basically, we divide into the phases of gathering the letters, gathering all the documentation needed, building a proposed endeavor that makes sense with the past of the candidate and with the future intentions that they have to actually put in practice in the United States. The attorney will write, so I write a cover letter defending, connecting all the dots of all that supporting evidence, and then we file the I-140 with all this package of evidence.
Let's also kind of complete the process too with either the adjustment of status or immigrant visa processing as well. So let's say the I-140 petition is approved. What happens next? If you could touch upon concurrent filing, when that would be applicable, and waiting for priority dates to become current, that component of things, if you don't mind.
Up until November of 2022, EB2 NIW was current in the Visa Bulletin, which means that once an applicant filed for EB2 NIW, he could also apply to adjust the status if he was here inside the United States on another visa. However, since that date, since the end of 2022, this is no longer valid. The Visa Bulletin suffered a retrocession, which means that now, while you can move forward and file your EB2 NIW, once you have it approved, you have a gap period of waiting until your priority date becomes current or is under the date of the Visa Bulletin to then be able to move forward with the second phase after being approved, which is becoming a permanent resident. Everyone that files for permanent residency, whether it's through family, employment, investment, will go through the second stage where I have medical examination, background check, and several other documentation. So if you have, suppose, an E visa or an L visa and you're here and your date becomes current, that means that you can adjust your status from the United States when your date becomes current. So we can send your I-485, and at that moment, we can request work authorization, international travel authorization, and send the proper form to adjust your status and your dependents. So at this moment, we're filing not only one form for the professional, but a form per person that is eligible. And if you are outside of the United States and your visa, the Visa Bulletin makes your date, your priority date current, that means that at that point, we'll have the National Visa Center sending your whole package to the consulate where you will have an interview with the consulate. And in this interview, they are basically going to ask you, so you want to be an engineer? Are you opening a company? Do you have a job offer? So you just have to know what is in your process. We help you prepare for this interview. It's usually very simple. And from that moment, you get a stamp in your passport that has the same validity as a green card, and you have to enter within 6 months of that interview already as a permanent resident, being able to work and bring your whole family.
Thank you so much. So yes, filing the I-140 with all that supporting documentation, that's a task. Getting the case ready to file, like you mentioned, the letters of recommendation, all the evidence that goes in with that I-140 submission, comprising hundreds of pages, that gets filed. Once that gets approved and the priority date becomes current, if you're lawfully present in the United States, you can do an adjustment of status, assuming that the requirements are met. And if you're abroad, most likely you're going to be doing immigrant visa processing. Let's continue this discussion and go into, what do you look for personally when you're evaluating a candidate for whether they could be eligible for an EB2 NIW? What are things that you're looking for?
Outside of the basic eligibility that I need to be there that we already discussed here, I always like to see candidates that went the extra mile, that joined different associations, that mentored students, that took upon themselves to do volunteer work within their professional field, that decided to publish, even if it's not scholarly published, but they did blogging. They try to put out there either through LinkedIn, but trying to impact the industry in positive ways, in leadership roles, all those outside of the box that every other professional has, is the extra mile that I can also argue to the officer that this person is top tier, extraordinary professional, and not only meets what I need them to meet, but has well positioning to advance the endeavor. So those are the main things. I don't like to say you need a patent, you need a published article, because that's not true. I've had very technical profiles approved without any of those. So you need to be faithful to your field, your background. But if you are an academic, a researcher, then go publish, go do the best that you can, doing an LLM, a master's right now. Go take as many associations and mentoring and debate clubs that you can, because it's all those little things that will make a difference at the end of the day.
To that point, it shows the value in an attorney's involvement in developing your case, because this is the kind of guidance that can take a case that's just on the cusp of being a viable case to becoming a very strong case by simply taking various actions to help demonstrate that you not only meet the baseline of the requirements, but that you're at the high end of really satisfying each of the requirements needed to be proven. Now I want to talk about industries. Let's make it very tangible for people. What sorts of industries can qualify for NIW, from those that are very intuitive, if you can share with us some that you wouldn't necessarily think would qualify for this national interest waiver, but that can certainly qualify?
Absolutely. Going through the intuitive first, of course, the STEM areas, I have several healthcare professionals, so medicals, nurses that we had approvals, dental workers, anyone in that arena. I have microbiology researchers. So not just being a teacher or professor, even though that's surprising to a lot of people, case of Danasar makes clear that just teaching is not a national importance activity. So if you do have a teaching background, but you were also an educator, you also took upon yourself to teach special needs children, you had an extra specific activity, we can use that aspect to defend you, not just the teaching activity itself. But if you are, for example, a lawyer, but you also teach in a university, so you do immigration law as a teaching on the side, and you are a lawyer, that is an extra. You're mentoring, you're going one step above, so your main defense is as a lawyer, but I will use the other activities as a well-rounded professional to demonstrate your distinctive merit to achieve the visa. So STEM areas, engineers, doctors, all those people, IT, there's a lot of search for machine learning, AI, cybersecurity, all the growth areas right now, but not intuitive areas that I see that a lot of people don't know that they are eligible. And this is also something interesting for entrepreneurs, is I had a very interesting case approved. That was a barber shop that had a very interesting business plan. He had something similar in his country of origin and he wanted to bring it here, but he wanted it to be a teaching kind of barber while he was also seeing clients in a very innovative way, using some sustainable products that were like green and organic, and we were able to connect all those dots to make something very innovative and different. And we had an approval for a barber. So you wouldn't think that that person could have a national interest importance, but he did. At the same time, I had a jeweler that had very specific achievements within high-end brands that not everyone could work those specific watches and mechanisms, but he had all that in his background. And he didn't even have an advanced degree, but the exceptional ability criteria, he met every single one of them with flying colors. So we got him approved. Another interesting case was for an architect that was actually denied, but had a very interesting business plan trying to use sustainable methods that increase the security for the construction workers. He was going into underdeveloped areas, and the officer did not see a national importance criteria there. So we reworked the case. We really focused on the economic development of the underdeveloped areas, plus all the specific methods that he was very technical and knowledgeable in. And we conquered the approval in the second application with a different officer seeing all that. So there are very specific niches that are actually eligible, even though it could not be intuitive. So I encourage you to submit your resume, to go through a consultation to analyze your specific circumstance and your set of evidence that we can build a strategy out of.
That's so interesting. So you have the STEM industries, which, as you mentioned, it's quite intuitive that these would have a basis to qualify. But then you're talking about a barber, you're talking about an architect and a jeweler. That starts to get very interesting. What did the barber do? How was the barber's petition submitted to demonstrate national importance? What was he doing beyond simply operating a barbershop and benefiting himself by engaging in this commerce? What was he doing above and beyond that put him in this category of national importance?
Absolutely. The whole idea of the business plan was very innovative, and it was a method that could be franchised and could be escalated in a very beneficial way. So he was trying to teach and do startups out of not only the barber technique, but the business technique side to help other young people that wanted to start in the business arena to learn how to be a barber and learn how to run their businesses and then go from there. And by demonstrating how specific methods he had to do that, we were able to conquer all the prongs and the approval.
Amazing. And it just goes to show you that if you're watching this video and you think, I operate some gas stations, I don't think I could qualify for this, you shouldn't rule anything out, because you never know, there could be an unconventional case that can be put together that can get approved for this category. And that's one of the reasons why this is such an exciting area of immigration law, for that very reason. So let's keep it going. We touched upon this earlier when we talked about the types of documents that go into an EB2 NIW filing, but perhaps we can go through it in a little bit more depth at this time.
Absolutely. We do use the guideline of the statute that the manual of the adjudicator itself has to demonstrate the evidence. So we go through the degree. So if you have a bachelor's, a master's, we're going to take the degree itself plus the transcript. We need letters of verification of employment, whether I rely on the 5 years that I need for advanced degree or the 10 years that I need for exceptional abilities. These letters of verification are from your former employers in letterhead, from the HR supervisor. Very simple listing, time worked, the dates of beginning and end, the role, the responsibilities. We need professional license if you have one. We need a proof of your membership in professional associations if you have it. Those are not requirements if you're going through advanced degree, but those are all beneficial if you do have them to add to the process. So anything that I allege and argue that you have, we're going to need to back it up with supporting evidence. So if you mention I have patents filed, I'm going to need proof of those patents to bring to the case. If you did lectures or published articles, we're going to bring those publications or at least the links to access them to support. Or you have several certifications or certificates, we're going to bring those. And it's important to note that any document in foreign language needs to be translated. And if you have 100 certifications, we're going to go through those that are actually relevant to the case. We're not going to present 500 certifications. We need to be assertive with the documents that we're presenting and is strategic, because the officer only has so much time to sit and look at the several papers that are going to be in front of him. So you want to build a very strategic case, even though it's going to be lengthy. Everything that is in there has a purpose to be there. So all this other evidence of recognition, including the letters of recommendation that are extremely important, are going to be on the top there of these files, including letters of experts, maybe going through a company that provides experts in your field that can validate that your work will meet all those prongs that we talked about. On top of all your personal documents, sometimes this halts the case because you didn't grab your birth certificate or your marriage certificate or a divorce decree or your kids' passports, and we need all that in order join with the application. And those are the main ones that we start working with. Of course, they will change according to each applicant.
So now we've covered requirements, we've covered the process and the documents and many things. I want to now go to processing time. Processing times are, of course, very important to people that are considering certain immigration options. So if you could touch upon what the processing time is for the EB2 national interest waiver process, whether premium processing is available for this process, and everything you'd like to share in that regard.
Once filed, they will give an answer in about a month with your priority date, giving you a 797 notice of receipt of your case. That is your priority date that we're going to use to compare to the Visa Bulletin. The EB2 NIW right now is backlogged for all areas of the world and the specific countries that are already backlogged for other visas. So nobody can at the moment file the I-140 and adjust the status at the same time. Everyone has a period of wait, whether that is up until 2023 or all the way back to 2012 for Indian nationals. Once we file the I-140, I've seen cases being approved in an average of 6 months to a year. Of course, there are cases even without premium processing getting approved within 4 or 5 months and cases being approved within 18 months. I give an average, but it highly depends on the officer and the backlog, and we have political other circumstances that can always affect this. I'm speaking about what is happening currently. Back in 2020, my average timing was of 18 to 24 months. There was no one getting analyzed before that. Having said that, premium processing is available for EB2 NIW applicants. Currently, the filing fee for premium processing is $2,805, and this requires an officer to analyze your case in up to 45 days. But when I say analyze, it doesn't mean approve or deny. It means adjudicate your case. Usually, and it happens more often than not, they can ask for a request for additional evidence, which means that they only had those 45 days. They need to give you an answer or an action within the time frame. And if they don't, they end up just sending a request for evidence, even if they wouldn't normally have sent one, just to move your case along and fulfill the deadline. So a case that goes with premium processing tends to have more chances to receive a request for evidence than a case that does not go with premium processing. That's the strategy that I like to analyze with each applicant, because if you're about to lose your status or you have any other circumstances, it may be worth the risk. But as a general practice, I am not pro premium processing just to accelerate it, period, because even after you get your case approved, the Visa Bulletin wait is still there. We're still going to hold your place in line, whether through the National Visa Center or to adjust the status later on, but you're going to have a wait time. Having an approval does not mean that you get immediately access to a social security number, to a work authorization card, or to international travel, or to green card itself. You just wait with that approval when the Visa Bulletin allows you to start all those next benefits phase, which I know is the ultimate goal for everyone.
Now that we've covered processing times, our audience, there's all kinds of people, but we also have a lot of entrepreneurs in our audience. Maybe they're in the United States on an E2 investor visa, they have a business of some kind, or otherwise. And I would love to discuss how entrepreneurs can utilize the national interest waiver as a potential option. So what are your thoughts on that? We've covered it to some extent in some examples that we've talked about earlier, but if you could share how an entrepreneur can utilize NIW.
There is a misconception, and I've seen it out there, rumors, people saying that opening a business is the only way to achieve an NIW, and that is not true. What goes for me as advice is the background of the applicant. If you've never been an entrepreneur in your life, you were always working as a dentist in a dental office for someone else. You didn't open your own dental office, and you come to US and you say, I am going to open my own dental office. I've seen that happening. The officer will come to you and ask, if you didn't even do it in your own country, why do you think you're going to do it here and have success? My burden of proof is only that it has more chances of success than not. It's not clear evidence. I don't have to pressure, but still, I don't have supporting evidence that that person knows how to be an entrepreneur. So the good news for the entrepreneurs is that I can absolutely use their background of startups, of innovations. These are usually people that are already going the extra mile because they know how to build a business from scratch. So they're always doing different things to launch themselves out there. So we can use all that they are already doing to demonstrate that they have more chances of success than not of opening a business here as well. So I usually have a lot of success with my entrepreneur profile clients because they do come come with a background and with the intention of keeping doing that. And usually what I need is to get the very specific set of circumstances that they have to present. So the barber, I'm sure there are many other barbers that could open a barbershop, but that guy was doing a mentoring, innovation, franchise idea that he had several points that only he was doing that we were able to leverage. So if you have an IT consultancy like that other example I demonstrated, that is programming and teaching how to do it on a national scale for a platform that allows banks to communicate within the central bank of a country, something like that. So your circumstances, projects that you may not even think that are that relevant, once you bring them to me, I will analyze that and say, no, this is what we're going to rely on to build your whole legal strategy. And sometimes it's something that you wouldn't even give that much stock to. But definitely the NIW is a great pathway for entrepreneurs, and we've had a lot of success for those.
And in the context of an entrepreneur that's going to be pursuing NIW, does investment amount in their business impact the case one way or another? Do you prefer seeing a large investment? Does it not really matter? If you could just comment on that.
There is no number amount required by law to demonstrate that that business has more chances of success than not. When I talk about NIW, I'm talking about a professional of advanced degree of exceptional ability. So someone that has certain level of recognition. So yes, it is important to demonstrate if whenever possible that I have a higher salary, means to provide not only for your business, but for your family. So we can rely on whether your W-2s or your tax returns from your country, if you were here from United States itself, or even letters of interest of potential investors, customers, partners, this kind of interest in funding or in partnering or in providing resources to help your business grow or to buy or to use your services is another way of demonstrating that you have more chances than not. And it's almost as important as demonstrating just a value, because at the end of the day, I have business like E2 where you can give a substantial amount not numbered and have temporary non-immigrant visa. NIW gives you a pathway to a permanent visa, but it doesn't require you buying your way in. It requires meeting those prongs. So having a high salary or a high investment could be beneficial, but is not the turning key to conquering this visa.
Thank you for making that clear. Now, shifting away from entrepreneurial activity and just, I want to better understand and I want to show the audience the degree to which having work available or a job offer, we made clear earlier in this video that the NIW, one of the tremendous advantages of it is that it does not require you to get petitioned by an employer. You can self-petition and you don't have to go through the labor certification process. That said, to what extent does an applicant for NIW need to demonstrate that they have work available in the US? Do they need to have a job offer? Do they need to have a letter of interest from a potential employer? Do they need to have contracts with prospective employers or prospective service providers or things of that nature to demonstrate a strong case? To what extent is it important? Is it completely irrelevant? I'm sure our audience would love to know that.
Those examples that you gave are not a requirement to have a successful application, but they are very strong evidence to fulfill all the prongs and conquer the approval. So it will highly depend on the profile of the applicant itself. I've had applicants that had recruiters trying to reach out through LinkedIn saying, hey, I'm interested in discussing this position with you. It doesn't have to be a formal job offer, but that initial interest was enough. But then I had officers that said, no, this threshold is not enough. You actually need someone that wants to hire you, even though this is a visa that doesn't require a job offer. So the officers themselves can be contradictory in this level of evidence. I don't want the applicants to go out of their way to try to fabricate or create evidence that is not there. But if you do have worked before with a governmental agency, or if you do have recruiters organically from US trying to reach out to you, if you do have contracts or potential customers or vendors reaching out to your business, to your consultancy, to your professional services, all those evidence are strong points to demonstrate your well positioning to already start executing what we're promising you're going to do.
Let's go into just some of your tips. I would love for you to share some of your biggest tips to somebody that's considering an NIW. What would you recommend for them, just in terms of general information, to help them have a successful outcome?
Absolutely. I would say get informed. There is a lot of content out there for you to understand this visa, understand the requirements, talk to an attorney. There are a lot of people out there trying to do this visa. And one of the biggest reasons of delay or denial that I have seen practicing? Are people trying to do it on their own or hiring someone that is not specialized in it? Unfortunately, when that happens, you can't completely change your endeavor or how you're defending your case in the middle of the way. So I've had several cases come to me in the request for evidence moment, and they filed everything in one way, and we have to work with what was already filed instead of starting a process from the beginning very well built, very solid and very strong. So inform yourself, speak to an attorney that is specialized in that, and be very cooperative, very detail oriented. At the end of the day, I learn a lot about all the different fields. I can guarantee you that I'm not an expert in programming in a lot of the areas that I discuss with my clients, but I need to understand it so the officer understands it. You need to understand that the officers are laymen. They are not specialists in all these different fields, and they have a limited amount of time to read your proposal, understand it, understand the impact, and approve. So my job is to understand the impact, build a strategy that the officer will actually understand as well to get an approval for your case. So the more detail-oriented, the more documents you can seek, the more cooperative you are with your legal team, the bigger the chances of success.
Amazing. Okay, now, what are some common reasons that an NIW case might get denied?
The first one, I just touched it briefly, filing on your own or filing with someone that is not specialized in it, just trying to wing it. This is not the type of visa you can just fill out a form. You need a substantial amount of evidence, articulation, meeting the threshold of the statute in order to achieve the approval. Number two is not knowing all your rights. So if you file on your own, back in the day when you were able to file concurrently, but you sent only one form and then the Visa Bulletin changed, a lot of people lost their opportunity to adjust the status and wait until they could get to the green card with the work authorization. So always consult your attorney. The Visa Bulletin is currently changing. The immigration scenario is constantly changing. So I do believe that those two actions are the biggest game changers for you to not get even more delays in your case.
So we've covered a lot of ground. I wanted to just open up the floor for you to just cover any other additional points that you'd like to mention.
I believe that the most important thing for people that are considering pursuing an EB2 NIW is really look at your resume, try to work in your LinkedIn, in your social profiling, because the officers do look into how you're portraying yourself online, publicly. If you can take any opportunities to speak up, to take any leadership roles, to volunteer in your professional field, start doing all that. Don't wait until, I'm going to file next month. Let me join a membership. Let me get media coverage about me all in the 30 days before you file. Start getting involved, get out there, really go the extra mile in your field, in your work. And by the time you come and you say, I think I'm eligible, I want to apply, all that little at a time, those minor steps will amount to a very strong proposal that we can work with.
Thank you. That's awesome. Giovanna, first and foremost, thank you so much for joining. I would certainly love to have you back. Thank you for all that fantastic insight. To our audience, thank you so much for watching the video and sticking around. If you know anybody that can benefit from this information, definitely feel free to share this video with them. We're all about empowering you with knowledge. So the more people that can watch this video that can benefit from this information, the better. If you like this video, make sure to smash that thumbs up button. If you have any questions, feel free to put them in the comments below. And as always, I will see you on the next video.